Okay, so we're going to continue our discussion of the UCC by going back to the parole evidence rule, which we discussed in the chapter before this with service contracts. And we focused there on when you can't use parole evidence because you can't use it to add or contradict the terms of an agreement. So with service contracts, because they have to be so definite, there aren't going to be terms. The only time you would be using parole evidence would probably be to add or change something to it, as opposed to something else, like explaining something that is ambiguous or missing, because that can't exist. You wouldn't have a contract under the common law rules for service contracts. But with the UCC, because things are a little looser, you can actually form a contract while some terms are missing and may also have some ambiguous terms. So this is a situation, and what we're going to talk about now is when you will use parole evidence and need to use parole evidence to indicate what the written agreement was, what was meant in the written agreement, and what was intended between the parties. You'll have to use outside evidence to explain what those missing terms should be, or what their understanding was, or what the understanding in the industry, or based on their past relationship doing business together, what those understandings were, so that we can help a court understand how to interpret the contract. So that being said, there are three basic ways this is going to come in. Again, not to change or alter the terms of the written agreement, but to do other things like explain or fill in missing gaps that are in the contract under the UCC. One, you might use it to explain the past dealings of the parties and how that explains some term in the contract. So this is the situation where you may have had, this may not be your first contract with this business. You may have had similar contracts in the past, and they may have behaved one way in 5 contracts that you had over the years, but then on the 6th contract, all of a sudden, even though we have the same language in the contract, they're taking a different position. And so we can use evidence of their past dealings. This is parole evidence because it's outside of what the writing says. In this case, we could use parole evidence to explain that their position now doesn't make sense. They're either being dishonest or disingenuous because we've always done it a different way before. So all those past dealings belie their contention that this is what the ambiguous term in the contract meant. The second is trade usage. And this is the industry standard, basically. Every industry is different, and they all have their sort of ways of doing business and customs that people, merchants who deal regularly in these goods know of. And there's industry standards. So you might have somebody, an expert in that field, testify as to what everyone knows is expected when it comes to a certain term, what it means if it's otherwise ambiguous to an outsider, that everyone in this industry knows that that's what that term really means. And this is going to become relevant in the case that we're going to look at in just a second. And then third, there's course of performance. This is similar to past dealings of the parties, but they're past dealings that pertain to this current contract. So you've got a contract for a year's worth of business, and they've acted one way for the first 8 months, and now all of a sudden they are taking a different position. You can use that to contradict, not to contradict, but to explain, to contradict their contention, but to explain what is meant by the writing, what the parties intended to mean when they said that, based on the way that they've behaved before. And that's also relevant to this next case. The case is called Griffith versus Clear Lakes Trout. And as you can imagine, it's about fish. It's a fishy case. Clear Lakes is a fish hatchery, and they had to deal with Griffith, which is a trout grower. So Clear Lakes would hatch the fish, they would give them to Griffith to grow them because they had the resources to do that. And the deal was that once Griffith used their expertise to grow them to a merchantable size to be sold, Clear Lakes would then buy them back. And what the contract said was Griffith was supposed to grow them, and once they got to be market size, that was when Clear Lakes was supposed to buy all the fish back from them. This was a 6-year contract. So this is a big deal for both parties. After 3 years into the contract, Clear Lake's the demand for the trout in the restaurant industry or wherever changes, and for whatever reasons, we don't know all of them, but the demand changes and people don't want they're wanting bigger trout. And before, what they had been doing is they'd been growing them to anywhere between 12 to 16 ounces, a pound to a little bit less than a pound, and that's when, for the first 3 years of the 6-year contract, or halfway through, Clear Lakes had been buying them back once they got to that size. All of a sudden, though, the demand changed and people start wanting larger fish, so Clear Lakes begins to take fewer of them, eventually stops buying them back because they're not meeting their demand by growing them only 12 to 16 ounces. Obviously, we end up with a breach of contract suit. Griffith is losing money that they expected to gain over the next 3 years because Clear Lakes is not buying them back. And, they've got a bunch of extra fish. Here, the contract, again, the writing says that they're supposed to buy them back at market size. That was their understanding. The problem, though, is that we don't know, the writing doesn't explain to us specifically what market size is. So a court can't really tell on the face of the writing who's wrong and who's right. And so this is why we need parole evidence for UCC contracts, because we're allowed to form contracts for goods with ambiguities and missing terms. Here the term isn't really missing, it's there, but it's just ambiguous. Market size obviously has a meaning within the fish industry, but we don't know what it is, so we have to use evidence of the trade standard, which is one way we use parole evidence. And the trade standard here was that trout, a marketable trout was supposed to be grown 12 to 16 ounces. That was what people had understood, and that's probably why they were buying them back at that size. The other part of this that's maybe most important is that this is a 6-year contract, and Clear Lakes, for the first 3 years, was buying them back. They didn't say anything about it. They were buying them when they got to 12 to 16 ounces. So obviously, they felt that market size was 12 to 16 ounces. So we're going to not let them contradict themselves now just because the market has changed, and pretend like they didn't know what market size meant, or that they didn't have an idea as to what that was. So that's, in this case, how parole evidence is used 2 out of the 3 ways, with trade usage and then the course of performance. And they may have had past dealings. I'm not sure that the case here says that. They may have had past contracts also. So again, the UCC is not going to let a contract fail just because it fails to spell out all of the terms, or because it has some gaps, or because some things are ambiguous. We'll still have a binding contract, and then we've got these rules to fill in the gaps, and then and also the ability to use parole evidence, because we're not using it to contradict or add to what the writing says. We're just trying to explain some missing terms. The UCC has specific provisions that talk about what to do when certain terms are missing, and it all kind of falls on, what's reasonable price. Obviously, whatever would be a fair market price is what it says essentially, or based on their past dealings, like in the fish case, if they've been accepting it at this price, they can't change their mind. And so we're not going to go into all of those, but just know that for any term that might be missing, the UCC has a rule that will explain how to go about assessing what it should be if we don't otherwise know. And then, of course, you have the ability to use parole evidence to explain what those parties meant in their context and at that particular time.